Let's go on the record on DC 213104, Bayless v. Doe. Counsel, make your appearances.
Jib Zadie for the plaintiff, Charlotte Bayless.
Karina Loya for the defendants, Theodis Thomas and Liquid Environmental Solutions, LLC.
Let's proceed.
Good afternoon, Your Honor. Defendants have filed a motion for spoliation sanctions against the plaintiff in this matter, and I would like to provide the court with background information. This is a personal injury.
I've read it all, just so you know. So
okay. So may I skip the facts of the case?
Sure.
Okay, perfect. So I will move on to the timeline of events here just briefly, Your Honor, because I know you've just mentioned that you read the motion. Essentially here we have a case where, lawsuit was filed.
Right. I mean, I've read this. It seems like an awfully harsh sanction that you're requesting on a situation where all the plaintiff did was repair their vehicle. Is there something unusual about this case that would cause this case to be treated separately than other regular car wreck cases?
Oh, yeah, of course. And I meant to go through the facts, but I will highlight why this evidence is crucial in this case, aside from just a clear liability case. Through discovery, the defendants were served with 911 audio recordings and body camera videos, which revealed a third party that collided, an additional third car that collided with the plaintiff. It is unclear whether that was prior to or subsequently to the alleged impact with the defendant, Thomas. So that is the key difference in this case, is that we now are dealing with an additional third unknown party that collided with plaintiff. When plaintiff initially filed her lawsuit, she didn't disclose that. She eventually amended her petition and then added the unknown third party. So here we are dealing with.
Did you get pictures of the vehicle's damage?
Yeah, we did.
Okay. And your client didn't, so you have pictures of the vehicle, so you can see that there was property damage, the property damage on the vehicle of the plaintiffs? Yes,
we can, Your Honor.
Did you, I mean, normally how this works, did the adjuster request an opportunity to look at the vehicle, or they just immediately deny the claim?
Well, it's kind of twofold, because we have not been given the opportunity to do anything with this case. Plaintiff went through her insurance carrier and immediately started the repairs. Well, the repair process. It's my understanding the repairs did not happen until April. So it's a couple, 2-3 months after, but our adjuster received a spoliation of, preservation of evidence letter. I believe it was.
Did your adjuster ever request an opportunity to go out? And it took 2 or 3 months for them to fix it. Did the adjuster ever request an opportunity to go out and chance to inspect the vehicle?
Again, the claim has been denied from the outset because we are disputing liability. And Your Honor, respectfully, I don't think that's the standard. The duty arises once a claim is initiated. And so that's what happened here. The very next day, she retained counsel.
So your position is that is in every car accident case, if the plaintiff is in a situation where the defendant refuses to pay for the vehicle, then they can never fix the vehicle?
No, not necessarily, not in every. I think in this situation where you have a plaintiff who files lawsuits and fails to disclose facts, and then we get the lawsuit, then we get the evidence and it's reviewed, that's the reason why this claim has been denied in the first place, because we don't have consistent evidence that shows that we ever made contact with the plaintiff's vehicle. So I don't think it's fair to say in every single motor vehicle accident case, but in situations where the damage to the car was not anything that prevented the car from moving, it was to the rear.
Well, you were provided with pictures of the vehicle, is what you said.
Yeah, of course. But, the science is different than pictures. The picture shows there was something impacted the plaintiff. We don't know what it was. And that's the entire dispute of this lawsuit. Otherwise, we wouldn't be here today.
Do you have any case law where a court of appeals or Supreme Court has said that a plaintiff in this situation has a duty to maintain the vehicle and not get it repaired after the insurance companies denied the claim?
Not that specific. I don't even think there's going to be any case law to be that specific. What I do have is just at least provide notice. This case just moved so quickly. It was like a claim was filed, we received notice, and then immediately.
I will tell you, Ms. Loy, I handled this type of law for 13 years. It was very standard and I'm sure anybody who's involved in a car accident, that vehicles get repaired quickly, right? I mean, it's not unusual that a vehicle would be repaired a week or 2 weeks after the accident occurs. I mean, that is very common in this area. In fact, I'd say that's almost everyone that I've ever dealt with. Not everyone, but the vast majority is dealt with. And so I'm just curious why this should be treated so differently.
Well, I go back to the unknown third party, and us again disputing liability. And as you may know, since you've been doing this so long, defendants, specifically when it pertains to an 18-wheeler, the damage to plaintiff's vehicle is not even consistent with an 18-wheeler.
I will say I've handled hundreds of these as an attorney, and also hundreds and probably thousands of these as a judge. I don't think I've ever had a defendant request spoliation in this type of situation. So what you're doing is very, very unusual. So it may be this is going to be the new thing that happens. I don't know, but I have never seen anyone request spoliation, especially in a situation where you have the photos. But this is why I'm asking the questions, is that this is an area that I've dealt with for years and years. I'm board certified. This is something very, very common, that it's just a very, very aggressive approach that you're taking.
Well, Your Honor, I have, again, already presented to the court why this is crucial. My expert can't go and base his opinions based on photos. That's not the way engineers work. And so that is why this motion was filed, because he's telling me I cannot tell you what happened. These pictures are insufficient. They're also in the dark. So it's not like we're getting clear-cut pictures where we can see everything. We cannot even put 2 and 2 together, not even with 3D. We've tried to do the dimensional, where we put a car like hers against the 18-wheeler. We're not getting anything. And so that's why, I didn't want to go into all the detail with the experts, because that's, again, going to be a fact issue. But this motion is, presented on that basis. And I respect your, decision, whether it affects us or not. But again, I have a client that I represent, and I am moving on that basis, Your Honor.
Mr. Zay, do you agree with Ms. Loya?
Not at all, Your Honor. And frankly, I think the motion is frivolous on its face. I think it's ridiculous to suggest that my client had a duty to maintain a vehicle that was undrivable for months in case the defendants decided at some point they would retain an expert that needed to see it. There's no.
You've been doing this a long time, Mr. Zaid. How often don't insurance companies usually repair the vehicles fairly quickly?
They do, Your Honor. And in this case, we have not only photos at the scene, we also have photos of the vehicle taken afterwards in the daylight. As Ms. Loya is saying that they're in the dark, we have daylight photos as well. We also have a repair estimate that's been produced to them. So, all the evidence that was available to produce before the vehicle was repaired has been produced. But it's certainly my client's duty to mitigate her damages. And so I don't understand how they can suggest that she had a duty to sit there with an undrivable vehicle and continue to rack up loss of use damages while they decided whether or not to retain an engineer. I think it's frankly ridiculous, Your Honor.
Ridiculous may be a little harsh. Unusual, I would agree. But anyway, I've interrupted both of you. Do you have anything else you wanted to say?
No, Your Honor. All I'll add is just I've just asked for our time and expense in preparing a response to this. Our briefing attorney briefed the issue, and I'm taking time out of my day to be here.
How much are the sanctions you're requesting?
$2,500, Your Honor.
Ms. Loya, what is your response to the sanctions motion?
Well, the response to that is that it's not frivolous for the same reasons I've already presented to the court. If we're going to go based on frivolous basis, then, we can file, again, sanctions as well for failing to disclose facts, just on the face of the pleadings. However, we're not doing that in this case. Jib and I have had several conversations. He is not new to any of this. I actually had a conversation with him about our motion. And, frivolous is a pretty harsh word to use in the first place, given the facts of this case that Jib is well aware of. We've had a lot of issues in this case. And so, we filed it on the merits and we stand by our motion, Your Honor.
If I may, Your Honor.
That last statement really concerns me. All right, response.
Your Honor, I'll just say the facts of this case, I don't think are dispositive. The biggest thing is whether there was a duty for my client to preserve this vehicle. And counsel has no authority to suggest that there was. In fact, all the authority suggests the opposite. There's a duty to repair. There's a duty to mitigate. And so if counsel is going to come here and ask for death penalty sanctions, there should be some legal basis for that. And frankly, there is not one.
Remind me, Mr. Zaidi, or either of you, have there been any other, my general approach, this is apparently sanctions day because we've had a lot of sanctions motions today. And one of my approaches is generally I don't award sanctions on the first kind of infraction. I want to give people a chance. And if there's a pattern, then I'll consider sanctions. I had 2 sanctions motions this morning, one where I granted the sanctions where there not been a pattern, although there was clearly kind of an issue with discovery. And then the other case where there had been a pattern. Is there some type of pattern here on the part of the defendants to
no, Your Honor, and I have nothing against Ms. Loya as an attorney. I think she's well qualified and a zealous advocate for her clients. I was only pushing for the sanctions to get our costs back in this case. But if the court doesn't feel like that's appropriate, I'm not going to push the issue.
All right, I'm going to deny both motions for sanctions at this point. Anything else we need to chat about? I think we have another hearing on this case. Is that right? A motion for leave?
We do. We can address it now, Your Honor. If you want us to come back later, we can do that.
It's up to you. Are these all the attorneys that need to be there for that hearing too?
Yes, Your Honor.
Yes.
Do you want to address it now or later?
Oh, we can do it now. I think our hearing's in 30 minutes anyway.
Mm-hmm.
Yeah, we have another hearing in between you. So if we can get it finished before 3, you wouldn't have to wait. So
I think we can get it done, right, Jib?
I think so too.
Okay. Why don't you go ahead?
So we also filed, Your Honor, a motion to designate Jane Doe as a responsible third party. I will not regurgitate the facts because it's on the basis of the 911 audio recording. I believe Jib did file his objection to it. And I think briefly in his objection, he stated it was not made timely. It's my understanding from the plain reading of the statute that we, if we're seeking to designate an unknown responsible third party, we do so by filing a motion to designate no later than 60 days after filing the defendant's original answer. But with that, we also have to plead sufficient facts to put them on reasonable notice of criminal conduct. I believe the statute reads criminal acts. And so in our original answer of specifically, this one's for Theodis Thomas, we stated specifically the violations of the transportation code that were violated by presumably.
You're looking at 33.004J.
Yes.
Okay.
And those allegations were made in our initial original answer, again, of Theodis Thomas. And, our basis for designating Jane Doe as a responsible third party was in light of the 911 audio recordings.
Response?
Your Honor, the standard for designating an unknown person as responsible third party, as you've pointed to, is in 33.004J. And it states that the unknown person has to commit a criminal act that was the cause of loss or injury. And in this case, there just is not a criminal act to point to.
Did the person flee the scene though?
No, Your Honor, they stopped. But my client read the way we were trying to identify them is my client read their license plate out on the 911 call. But I think my client made a mistake in doing so because the plate that we identified from the call is actually hanging in a workshop in Oklahoma and has been there for years. So it could not have been that one. So
No, but did
the
the, I mean, what
testimony
I'm
was
saying
that
is,
the other
did
driver
John Doe,
stopped.
did the John Doe flee the scene?
No, I don't believe so, Your Honor. I think the testimony was that the John Doe stopped, but then because there was no damage from that impact, they were allowed to leave.
Your Honor, may I respond?
Yeah.
The Jane Doe actually stopped. We don't know for how long. Plaintiff's testimony was that she briefly stopped, gave a wrong phone number to the plaintiff, then left and said, I'm going to be back. I'm going to go get my husband, and never returned to the scene. Didn't provide her name, didn't provide driver's license, didn't provide insurance information. She simply gave a wrong phone number and never returned.
Is one of your arguments that fleeing the scene was a criminal act, and that's part of the basis of your Jane Doe designation?
Yes, Your Honor.
All right, go ahead, Mr. Zaidi.
Your Honor, just in response to that, 'cause this is an argument we hear quite a few times. The response I've always had to this is that the criminal act must be the cause of the injuries. It's what the statute prescribes. Leaving the scene cannot possibly cause injury.
Oh, you're right. You're right, that is how it's written. So what would other criminal act would there be? What's the way up? It's not fleeing the scene.
Well, we identified and I'll read here. I identified not only the failure to return to the scene, but also the failure to provide identifying information in order to allow plaintiff the opportunity or not to pursue a claim against the unknown party. And then, obviously I went in through the Texas Transportation Code, speeding and all sorts of other stuff, negligence, willful and wanton disregard for safety of others.
This has come up quite a bit lately, actually, the 33.004J analysis. And I'm trying to remember, are there any cases that apply violations of the transportation code that say that that's a criminal act that can be used under 33.04J? I think, Mr. Zaidi, maybe it was you, maybe not, that there was a big issue in another case about whether or not that was that you?
That was me, Your Honor.
Okay. And what was the case law on this?
I don't recall, Your Honor. Just the quote that sticks with me from that one was you telling the defense attorney, you're trying to fit a square peg into a round hole. That's all I remember about that hearing, Your Honor. I'm sorry.
That sounds like me. Okay.
Your Honor, I have not seen any, obviously in doing my research, I haven't seen case law where it says you have to identify conduct under the Texas Penal Code, which I think Jib made that argument in his response. I wish we had a lot more clarity from the appellate court or even the Texas Supreme Court, but we have seen this come up in our firm as well as an issue, whether you have to identify actual criminal under the Texas Penal Code, or if it's under the same standard as, a negligence-based action. So I defer to you for that.
Yeah, when is this case set for trial?
March, I believe, 2023. Is that right, Jib?
I'm checking.
I know it's next year.
Yes, March 7th.
My thought is that I would urge you to do some more research on this to see if there are any cases on the transportation code. I thought there was maybe whether or not a violation of transportation code is a criminal act under 33.04J. I have a vague recollection that there is case law, but I may be wrong. But my thought is if there isn't any case law that directly says, hey, that would be a criminal act, or maybe certain violations of the transportation code are a criminal act and certain ones aren't, or something that defines what a criminal act is exactly. My inclination is to go ahead and strike the designation, but give you the opportunity to reconsider if new case law comes out or you find new case law. That's kind of my that's kind of how I'm leaning at this point. What did I do in the other case? Do you remember, Mr. Zaid?
You denied the motion, Your Honor.
Denied which motion? Your motion or their motion?
Their motion to designate.
Doesn't. Okay, so I want to be consistent then. But if there's any case law that comes out, Ms. Loya, I don't have a strong feeling about this because I think the statute's kind of unclear. So if you find anything that applies this, even if it doesn't have to be the transportation code, but something beyond the penal code, you know, that would be analogous, I'd be glad to look at it. But it definitely, in my opinion, is not just a general negligence-based action. You'd have to show some kind of, obviously, some criminal act. If there's a drunk driving, you know, allegation or something like that, that could be obviously a basis. But there doesn't seem like there's anything like that here. So, Mr. Zaidi, go ahead and get me an order on all of this. Share it with Ms. Loya. And do we have anything else we need to go over?
That's it, Your Honor.
No, I think that is all. Thank you, Your Honor.
Thank you. You guys have a great day.
You too.
Thank you.
Yeah, bye-bye. Okay. Oops.